Great. Thank you, Michelle, for the recording and hosting. As she mentioned, I am Brian McCarty, certified financial planner. I've been with Castle Rock for the better part of a few months now, and we're really excited to be escalating the educational portion of Castle Rock services. In some ways, starting with this webinar about estate planning that we feel is a good topic to remind ourselves about during the holidays as we're surrounded by loved ones. So today's going to be a high-level overview. We should mention that we are not attorneys. We don't draft these documents, but we sure handle them a lot when it comes to helping people with their financial planning matters. So everybody should be seeing the estate planning workbook on the screen now. This was actually part of your invite from Cindy. Cindy, if you're here, if you're not here, thank you for sending that out. We're also going to put that in the chat. And you can download it now if you so choose, and you can work on it as we go along or save it for when you're with your significant others or whenever it's convenient for you. But the idea here is this estate planning workbook is going to give you the high-level points of what you need to complete your documentation. This first page here is the basic of checklists, the wills, the power of attorneys, the living wills, things that we're familiar with. This line here showcasing a couple of resources that are available to everybody. One of my educational calls today, my one-on-ones, mentioned that NORCAN Group possibly has an educational legal help tool to look into, the details of which I'm unfamiliar with, but it's a possibility that it's in a benefits package already. Moving on to this piece is the idea of wills and trusts. One of the most common question I get for estate planning questions is, do I need a trust? And the answer is potentially. Not everybody does need a trust. Everybody should have a will. The details of your trust get more complicated when your assets increase or you have multiple pieces of property that need to be left behind. Even a single piece of property, if your spouse or is deceased or you are alone, should the potential for a trust increases its usefulness. And we'll talk about that more later. What are the key points of a will that you need to consider? If you have children or pets or even adults in your care that need someone to help them if you were suddenly gone, your guardianship provision, knowing who your primary and backup guardians are in the event that you have predeceased those that need your care, is an absolute key component of will creation. And typically what people start, that's when people typically start to think about their wills, is if they have children or other people in their care. The thing that everybody needs, however, regardless of children or individuals in their care, is your executor. Your executor is the person that will close the book on your life and handle the disposition of your assets and the disposition of you in the event of your passing. Everything, your wishes, your goals will be their responsibility to fulfill. And you're able to fill that out here, and it will have a backup because the executor may find themselves in a position that they don't feel responsible enough to handle this when the responsibility is placed on them. Having a backup is a good idea to try to make sure that someone is around to handle these responsibilities. Medical power of attorney and financial power of attorney. In short, power of attorney simply means you are designated somebody, whether it's medical or financial, to handle your responsibilities if you are not able to make the decisions for yourself. In the event of your incapacitation, power of attorney can deal with your medical questions with your doctor. Financial power of attorney can purchase and or use assets for you in the event that you need to either pay your bills. Again, if you're, I always think of a coma. If you're if you're unconscious for a long period of time, people need to have the ability to utilize your assets when it comes to financials, or just make decisions on your care. We want to point out too that the power of attorney does not necessarily need to be your spouse. You should choose someone that you feel has the mental capacity and responsibility and willing to be responsible for these decisions on your behalf. If it's your spouse, so be it. But sometimes it's, ask them, are they willing to make these decisions? Medical especially can be a very emotional time period if a power of attorney has to step in. So make those decisions carefully. Other parts of your will include where your assets are. How do you want them to be distributed, and to whom? It's going to be a case of, normally a lot of people just leave everything to their kids in equal portions. But the idea is, if there is something in particular, whether it's a cash dollar amount, a piece of jewelry, a piece of property, a car, that you wish to distribute to someone in particular, you're going to put that stuff in this area here. And again, if you have kids, or if you have charitable desires, or gifts in particular that you want to make to individuals or charities, you're going to want to list these things out. Again, this is a workbook that captures your thoughts so that when you make the will, you don't forget anything. That's the idea here. This is not a will, everybody. This is, make sure this is step one in your process to estate planning. What financial institutions do you have business with? You have IRAs, you have taxable accounts. Do you have crypto? Is it something in a wallet, in a drawer? It's when it comes to crypto. These things get lost all the time. Making records so that everybody knows where your assets are is important. Anywhere you have an address, whether you own the real estate or you have it perhaps with a business interest. Have you reviewed your beneficiaries? Yes or no? Remember that beneficiaries are not in any way covered under a will or trust. You must have designated beneficiaries on your IRAs and your life insurance policies, and make sure that anytime there's major life events, those are still applicable. Marriage, divorce, birth of a child, incapacitation or death of a family member. These things all need to be under consideration when you're making your beneficiary selections. Your other documents, such as your living will, are very important to determine what kind of care you want at perhaps the end of your life. If you're willing to receive care in all cases, if you're willing to perhaps, if the idea of receiving chemotherapy is too intense for you and you'd rather see how your life plays out without it, these are the kinds of decisions that you need to make. Do you want to donate your organs at the end of life? Do you want to be on life support? These are all considerations when putting together, not your will, but your living will. We kind of flew through that, but that's okay. The idea is this is a high-level overview of the pieces that are important in will creation. And we're going to talk about why we get into will creation in just a second. But the last couple pages here, if anything was unfamiliar to you, gives some solid definitions of the key pieces of your entire estate planning booklet, which should be looking kind of like this thick by the time you're done. I'm going to switch over to a more traditional PowerPoint now that we've kind of given you the high-level overview of your workbook. And you can take that again. It's in the chat. If you joined in late, that workbook is in the chat for you to download. It was also in the email from Cindy, and you can get that at any time. If you have any problems with it, let us know, or any further questions. But the more elaborate presentation today is discussing why we do estate planning in the first place. And everybody knows that word probate. And probate is the demon that we're trying to exorcise when it comes to doing estate planning. If you die without a will, the first thing that happens is we have to try to figure out where all your assets go. And if we can't figure that out from something that you've done, the government, which is known for its ability to handle money in all cases, will step in and try to do this on your behalf. And guess what? They take nice chunks out of your estate for no reason other than they think they know better than you do. So let's get this stuff done, everybody. It is a state court supervised process, delegating the execution of your estate because your will was not around to designate an executor on your behalf. Every state has their own laws when it comes to probate. There is a uniform code, but only 18 states adopt it. We wish it was more, but here we are. State laws are great sometimes, but in this case, there's a lot more confusion than not. Why should you try to mitigate it? Well, we talked about that. We don't want the government involved with your assets. We don't want to have to liquidate assets to cover government services when it comes to deciding where your assets go. the other part of this is if you don't want something particular, such as this example here, if there is a piece of jewelry that you feel should go to a particular person in your family, whether it's a child or perhaps even a sister, but you're married and you pass away, the court, will pass it on to your spouse more than likely, and then the spouse either has to determine that that goes to your sister, or perhaps he dies prematurely as well, and it ends up going to a member of his family because no one was around to say anything about it. It's very important we get these things done. Last will and testament is, of course, the key piece here when it comes to probate. It's your playbook. It's your guardian, as we talked about before. It's your executor. It's where your sentimental assets are going. It's also who you're excluding from your asset pool. If there's someone in your life that you absolutely do not want to have assets, if you feel like they are comfortable enough and don't need your support, it's worth mentioning them specifically, because otherwise it just looks like you've perhaps forgot to mention them. You want to exclude people that aren't involved in your will. What can't the will do? It can't determine, again, your life insurance policy recipients, your 401ks, and your houses, any property you have. It must be through either a trust or a beneficiary deed. Every state, again, has their own rules and regulations when it comes to passing what's called real property, which is basically anything built on top of dirt. This is not cars. This is just your homes. So make sure your beneficiary designations are set and are accurate at least once a year. Want to remind yourself to check in on those, especially after any kind of major life change. Trusts are very circumstantial. They are a powerful tool, especially if you have minor children and you want to make sure that assets are given to them on a time basis. A lot of people have the idea that their children somehow aren't able to handle large sums of money at 18. I don't know why, but that's just something that people do. But in any case, a very common structure that I see is if you are trying to leave a sum of money to minor children in the event that something major happens to you, perhaps the rules are set that the child may receive 30% of the money at 21, 30% of the money at 25, and the final third at age 30. Well, you can't do that unless there's a trust involved and there's a trustee designated to determine and give and govern those assets on behalf of the minor child. The trustee, just like your executor, should be someone you trust, as well as have a backup trustee in the event your individual, when the time comes to be their guardian, is not willing or is not able to do these things. Trust is also very, very important, and pretty much across any state can be used to pass on your assets when you pass, such as your home. It's really beneficial to leave a home to trust, and it will completely avoid the probate process. Trusts are, however, traditionally quite expensive to set up. They can, especially if you go through the normal attorney process, they can range anywhere from, I've seen, to be in the neighborhood of $2,000 to $4,000 to set up traditional estate planning and trust through an attorney. But there are assets out there. You can feel free to shop around for any attorney services in your area to find one that works for you. And we'll have a link to attorney lookup service for local help at the end of the presentation. Estate planning is not just for, we talked a lot about what happens when you die, but what happens when you're alive. Here we're discussing, and a few of these we've touched on it through that workbook, but the living will, the financial power of attorney, the medical power of attorney, HIPAA waiver is a new one for you, and becoming a durable power of attorney. These are all pieces of the puzzle that all have to do with when you are currently around and able. We set these things up so that in the event of incapacitation, or just we don't have the capacity to make all of our decisions for ourselves. For instance, let me save that one. Let's talk about living wills first. A living will is the playbook reference, again, to determine what you're going to do when you are incapacitated and you're getting close to your end of life. What do you want people to do for you when you can't speak for yourself? Are you going to want them to pull the plug? Do you want to be on life support for an extended period of time? Do you want the doctor to give you a solid chance before we terminate life support? These are all things that you can do, designate, tell people what to do without being able to talk. Also, if you're in just too much pain, there's just whether you go to hospice care, things like that. It's just living wills are such a powerful tool, and it takes the burden off of your relatives if you have this in place when the time comes. Your financial power of attorney is the reference that I held back on before. The power of attorney is great for not only incapacitation, but perhaps you are willing to give someone the power of attorney so that you are able to designate a representative for yourself to go out and make financial decisions for you if you just don't have the capacity to do all of these things in your day-to-day. That's a huge amount of trust to put on somebody. But it is a potential for you to do so, depending on your station in life. Most people use the financial power of attorney in the event that they are in an accident, or just, again, that word keeps coming up, incapacitated, to make financial decisions for themselves. And bills keep coming no matter what. I think that was the biggest joke I had with the pandemic is, everything shut down, but those dang letters just keep coming in the mail. Financial power of attorney is great for those matters. Real estate, taxes, government, anything you can think of with a dollar sign that touches in your life, which is pretty much everything, has to do with the financial power of attorney. Medical power of attorney is quite frankly, is knowing what is going to make the best decisions for yourself. If, again, incapacitation, if you want to receive certain types of care and not other types of care, putting this on paper for the people that care about you so they know what decisions to make on your behalf is quite crucial. The sister to the medical power of attorney is that HIPAA waiver. HIPAA is the government basically act. It's the Privacy Act that you cannot access other people's medical documents. It's very important to be able to access these documents, especially if there's specialists involved or things are out of network and they can't share information easily. This is actually a background I'm very familiar with. When it comes to talking amongst networks, they need to access medical information. If they can't have you approve the medical documentation requests, they're going to hit brick walls. And if time is of the essence, we need to make sure that these documents are transferring when needed. And if they don't have someone that's able to authorize such transactions, we're just going to slow down the process and potentially end up with you receiving lack of care or just slow care in these circumstances, which can be devastating. If you are, everything is power of attorney, that we talked about before, the simplest people refer to as durable power of attorney. They're sometimes used interchangeably, but in reality, the word durable comes about in the event that you are unable to make your own decisions, quite frankly. There's just keep your eye out for that word when needed, but it's basically when most people talk about power of attorney, it's because they are incapacitated, and most of the times they are durable when actually utilized. We are, again, unfortunately not attorneys, but we like to play them on Zoom meetings. We have the ability to point people in the right direction. We love to review these documents when we're doing one-on-one sessions, as well as full-on financial planning for individuals. But you will see here the estateplanning.com link, which is simply an estate planning attorney lookup tool. And we also have a couple links at the bottom here, some of which are in your workbook, that allow you to look up will creation tools, and they can point you in the direction of other power of attorney, and those are very important documents for yourselves. Once again, we are Castle Rock. We are your 401k advisor, but we also do our financial planning work on our Onward division. And we just wanted to step up these educational pieces. And with the time we have left, I would like to open it up to any particular questions that people have, concerns. If there's anything that you'd like to ask, I'd open the floor now.
Yeah, Ryan, I have a question.
Sure.
Is it true that if you have beneficiaries on all your financial accounts, that only your house will go through probate if you don't have a trust?
That is mostly correct. So depending on how much you have access to in assets, so if your bank accounts are designated transfer on death, it's a TOD. That's essentially forcing a beneficiary onto your bank accounts, because unlike IRAs, for those in the room that don't know, unlike retirement accounts, a bank account by default does not have a beneficiary. You actually have to ask them to place a TOD on your accounts. So if you have those set up and your IRAs have beneficiaries and your life insurance accounts have beneficiaries, your cars and other stuff in your house is going to go through I forget the name of the form, but it's another piece of the puzzle. It's basically small estate affidavit. Thank you, brain. Small estate affidavit will cover your small assets in your house, your cars, your furniture, and everything else. For most people, the answer to your question is yes. For most people, the answer to your question is yes. Depending on what asset pile you have outside of traditional accounts and cash dollars, the answer to your question is yes. You can still avoid the probate process with the home if you have the home titled appropriately, given your state laws.
Thank you.
Sure. Good question. Anything else?
Would you refer to that on the beneficiary deed for the house? Would you explain what that is?
Yeah, absolutely. So essentially, most people buy a home. It's just you simply are buying it, either with a spouse or by yourself, and the titling is your name is placed on the house. The purpose of the beneficiary deed is kind of like the idea of forcing that TOD on your bank accounts. The beneficiary deed steps in at the time and specifically mentions a beneficiary to your home. And it is a very clear court registered document that allows a beneficiary to step in and take ownership of the home upon your passing and avoid that probate process. And most states like Illinois and Colorado both have the beneficiary deed process, and it's very simple to do. As always, if you want to have an attorney review these documents for you, you're more than welcome to do so. It makes it more official in some cases. But in reality, as long as the court registers it and it is approved and is an approved document, the template is pretty flexible. So it's not always needed to sit down and spend $400 to $1,000 with an attorney to make these things happen.
So are you saying that even if, I'm sorry, go ahead.
No, Cindy, please, yeah.
Are you saying that if both spouses are on the deed for the property, it still could end up in probate if you don't have a beneficiary deed, depending on your state laws?
If both spouses pass away before a beneficiary deed or the house is placed in trust, is placed on the home will go through probate.
I mean, if one spouse passes away, but both are on the deed, does the other spouse automatically take possession with no court intervention?
Thank you for that question, Cindy. If you own things, it could be a home or it can be a bank account. If it's entitled jointly, it will go to the joint owner regardless of marriage. So if any property is owned jointly, it will automatically default to 100% to the joint owner upon one partner's passing. In the event you're both in the same car, now we got some probate issues.
Gotcha.
Can you hear me?
I can.
On that subject, does it matter if it's and or in the name of the owners?
Take me through that a little bit deeper.
So you have the spouses in the name of the title, it could have
Mhm.
the husband or the wife or husband and the wife. Does that matter?
I'm trying to think of what tenant situation that would be. If it's a tenants in common situation, a tenants by entirety, it should not matter and or
Okay.
there's going to be a more official title. Is this a bank account you're referencing, Loretta?
No, I'm referencing a house because my stepmom passed away, and so it left my sister, which is her only child,
Mhm.
received half of the house, even though she
Okay.
wasn't on the deed
Okay.
because of her mother. So that's why, and I was told it was because of the way the naming on the title, and versus or.
I'm
Hmm.
I'll be completely honest. If the and or situation throws me, because I traditionally work with a tenants in common, a tenants by entirety, they're joint with rights of survivorship. These are the official monikers of ownership. So the and or piece is throwing it. At the end of the day, when we look at the title of whatever is in question, if the asset itself has multiple names on it, there's going to be some level of percentage ownership. It's usually 50-50 if it's two names. And at the end of the day, if there's two names on it and one of them is now gone, traditionally it all would go to the other individual. But so it's certainly something that you and I could dig further into if we want to set up some time.
Well, it was mainly for Cindy because of the situation that my father was in. So, yeah.
Sure. Well, that goes for everybody. If there's a question
Yeah.
not answered today, we'd happy to go through it at a later time. Thank you, Laura, for the question.
Yes.
Brian, thank you for your presentation today. That was excellent. It was really helpful. I learned a lot, actually.
It's my pleasure. My pleasure. Thank you all for attending.
Yes, thank you.
Have a great afternoon.
Thanks,
Michelle.
Ryan. Thanks, Michelle.
Thank you.